Number 117. Counsel? Would you like any rebuttal time?
Could I have 2 minutes, please?
2 minutes, sure.
Thank you. I'm Mark Davison, representing Stanley Brown on this appeal. The appeal raises two issues, both of which involve the allocation of the burden of proof that this Court addressed last year in the Gelati case.
What was the test that the appellate division used?
Well, the appellate division affirmed without a writing, but I think this Court can.
How do we know what test they used?
I think all the Court needs to do is look at the standard that the Court, that the Fourth Department applied before this Court decided Gelati, including in the Gelati case itself, and after. In a case, a particular case, the Scott case, before Mr. Brown's case came up, an attorney specifically raised the issue of the Wyatt case from the Second Department, which was the preeminent case at the time. And the Fourth Department's reaction was to put a CF to that, to Wyatt.
Well, it's easy to tell. I mean, it's not in this one, but it was clear and convincing before. Then there was this one, and it was clear and convincing after.
Right up until this Court's decision in Gelati.
But do you have a preservation issue with respect to your particular case?
I don't believe so, because when this Court has said that there's a preservation problem, it's been because there was no request for a downward departure at all. And here the trial counsel did specifically request a downward departure, cited to a Second Department case. And I submit that it would have been unreasonable to expect.
The cite to the Second Department case wasn't for the standard, was it?
It was
for the merits of it.
It was to the merits of the downward departure issue. But I submit that the trial judge in this case was in Jefferson County within the Fourth Department. The trial judge was constrained.
Are we to assume that the trial judge always follows what the appellate division or even the Court of Appeals says?
I would like to think that they do. But
if they're aware of it.
As far as I'm aware, they do the best they can.
But you didn't argue, did you, about the proper standard to be applied in the lower court?
There's no argument in the record about the application of the proper standard. But I submit that asking that would create an unreasonable preservation requirement on the trial attorney. The trial attorney would have to not only flag the issue, but ask the trial judge to follow the law of the Second Department in this case, and not the law as it had been outlined by the Fourth Department. I think by raising the downward departure issue, I think that trial counsel satisfied the preservation requirement that this Court alluded to in Fazio, which was a companion case to Gelati, and in the Johnson case, 11 NY 3rd, where the preservation problem was the failure to request the downward departure at all. I believe this case has to go back not just to the Fourth Department to address this issue, but I believe it has to go back so that the trial court can address it as well. In particular —
What's the merits of the argument, though? What supports the downward departure? Under the correct standard, as we've decided in Gelati.
The correct standard is for downward departure is preponderance of the evidence from Gelati. And I think that it's best illustrated by the second issue in this case, which is the certificate of relief from disabilities. Mr. Brown's trial attorney pointed out that there had been a certificate issued, in this case by the same judge.
Was that on the DWI?
On the DWI. It was, I believe DWI was 97 or 99. The certificate was handed down in 2002, and
Would the certificate apply to sex offender registration as opposed to what we normally expect the certificate to apply to, for example, employment or some other civil situation?
license.
Yeah, license or something like that. So are you saying that it would apply in this context in SORA?
I think it does under the language of Section 701. It applies for to relieve you to relieve a convicted felon of any disability, not just for employment or licensing.
I'm a little confused. I thought in the trial court you were arguing about double dipping between factors 9 and 11 when it came to the DWI. And I know that the certificate was mentioned, but was there any argument that it raised the presumption of rehabilitation and that the presumption had to be rebutted or anything of that nature at all?
Not in that level of detail, but I think that that was the point of what counsel was trying to say, that this that Mr. Brown was being assessed points twice, both under I forget the factor number now for alcohol and substance abuse, but also because his prior felony happened to be a DWI, and I think the point that the trial counsel was trying to make was that the certificate relieved the disability of that DWI conviction, and he shouldn't be assessed the extra points under that factor 9 as well.
By the way, was the certificate ever presented? Was it ever?
As far as I could tell, it was not presented. I attached it to my reply brief so that this Court could see it. But as I pointed out in my reply brief, it was the same judge who had granted the certificate. When the attorney alluded to the fact of the certificate, no one challenged it. No, there was nothing to rebut it. And I think that puts this case within Gelati, because he met his burden of going forward with a preponderance of the evidence. He put it out there, and no one did anything about it.
In Gelati, to be within Gelati, I thought in Gelati that they requested a downward departure but didn't request a standard, and you're saying we're a little bit better than that. We're within that framework in terms of preservation, right?
Yes.
Is that what you're arguing?
Yes, we're within the Gelati framework. We're outside of the Fazio framework where it wasn't preserved, and we have a situation where the trial court ought to have made findings as it is required to do under Section 168N of the Corrections Law, and it didn't make a finding.
One quick question. If we took away the 15 points under Factor 9, which is the prior felony based on the DWI, would that change the presumptive risk level?
It would not change the classification. He's still – it would bring him down to, I believe it's 120 points. It's still above the 110 required for Level 3. But it puts him in a better position when he's asking the judge for a discretionary departure. If you're that close to a Level 2, then, you know, maybe this other stuff will come.
Sorry, Judge,
You mentioned discretion, and that's what I wanted to ask you about, counsel, because bringing up the certificate, and you mentioned a couple of times that it was the same judge who is now the SORA judge who had granted your client a certificate of relief from disabilities. And so isn't there this alternative theory that the judge did exercise discretion, regardless of what standard the judge used to assess the departure, assuming it was preserved? I'm not suggesting that I agree that it was, but assuming it was, didn't the court exercise discretion, and isn't the court allowed to exercise discretion in denying or granting a departure?
I I would agree, except to the extent that, as this Court said last month in the Dempsey case, that when you've got a certificate, when you've got proof of rehabilitation, the Court has to at least address it. And whether – I think it was an error of law for the Court not to address it at all.
You mean on the record?
On the record, yes.
Even though you concede he probably knew about it.
He probably knew about it because he had signed it and it was brought to his attention, but he didn't address it on the record.
But
He
yeah,
didn't
I
exercise.
thought your point is he knows about it, but he may not necessarily think he can take it into consideration.
Well,
Did I misunderstand?
It does appear on this record that he may not have thought that he could take it into consideration, but from Mr. Brown's perspective is that it was out there and no one addressed it, and somebody should.
Thank you, Counsel.
Good afternoon. May it please the Court. Hannah Moore, New York Prosecutors Training Institute of Counsel for the Jefferson County District Attorney's Office. I want to talk first about preservation because I think that's really important in this case.
Well, there's an old phrase, I can't remember the whole thing, but in the appellate division where there are issues that simply can't escape review and don't need any further explication that appear on the record. Now, if we have a case here where it's very clear that the standard is preponderance, and it's very clear that the appellate division has consistently used clear and convincing, wouldn't it just make sense rather than expect another procedure? I mean, just clear that up and send it back and let them make their decision based upon the correct standard, since they're now following Gelati?
I don't think so in this case, because I think the danger here is that we don't know from anything stated what was used, but we do know the strength of, or weakness rather, of the evidence that was before the Court.
I'm not suggesting the evidence, and I know there's talk about a lot of rehabilitation and things like that. I'm simply saying, do we say to the Fourth Department, you know, you've been doing this for a very long time wrong. I see you got it fixed now, but all the ones you did wrong, we're going to leave there. You can just don't worry that you messed up, that you used the wrong law. We're going to cover it for you.
No, I don't think so, because one of the dangers
You'd be better off sending it back and saying, and they may do exactly what you're suggesting. I don't care if it's clear, convincing, or beyond a reasonable doubt. This is going to be a level 3, but they ought to at least be able to do that, right?
Well, I think here the evidence, you know, as a matter of law was insufficient. I think the evidence that the defendant put forth failed under either preponderance or clear convincing.
But why wouldn't, I think what the judge is saying to you, why wouldn't we make crystal clear that this is the standard that even you have acknowledged you have to use now, do it under that standard, and if the evidence is no good, what is the harm, and yet it would seem that there's some good to come out of making sure that we make clear to them that all this time you've been using the wrong standard?
The harm, first of all, is that the defendant in this case at this point could have actually asked for a subsequent downward modification where the standard would be clear and convincing. So by sort of allowing this kind of playing of the system where the issue.
Why don't we play the system? Somehow somebody let them get up here.
The issue was not preserved. And now he's able to, if it gets sent back under the lower standard, it sets up this kind of duality that doesn't make sense.
Well, you can make the argument, Ms. Moore, that what you're doing is you're standing here saying, I know there's 5 judges in Rochester that would prefer for me to make the decision, and I want to, on behalf of the appellate division, say we don't want to use the right standard in this case.
Well, I think importantly here, there's no indication that the wrong standard was used, first of all.
You really have serious doubt as to what standard was used?
I do, because I think
there's a couple people on this Court that probably are going to think that they probably did clear and convincing.
And that's fine, because, again, under either standard, the evidence is important here. This is a case.
What are you saying? It would just be an exercise in futility to send it back and have the appellate division apply the right standard?
Well, I think that should this Court infer that the wrong standard was used, that, yes, the correct action there would be go back to the Fourth Department.
Why is the evidence insufficient? Why has he not got something that is at least a colorable basis for arguing for the downward departure?
Because here, first of all, most of the evidence that we're talking about, as my opponent said, was actually not before the SORA court, and I think that's very important. Neither the specific arguments nor the specific evidence that we're now talking about were actually in front of the SORA judge. And I think, and also...
The certificate?
I'm sorry?
You mean the certificate?
Both the certificate as well as the claim relating to the change in relationship with the victim. The changed order of protection was also not before the SORA court.
Well, the certificate that judge ordered it, right?
Yes, right. And again, that goes to the points to the fact that this SORA court knew the evidence, knew the case before it, and took all of that into consideration.
Is it clear that the judge understood that if it were to be the case, that the judge could take into consideration the certificate? Is there something to let us know that?
Well, yes, because this judge, both the hearing record makes clear the defendant spoke to the court and detailed some of these instances, and the court, there's no indication, in fact, the indication that the court knew the defendant's history with alcohol, knew the prior felonies, and again, even if you remove those 15 points, the defendant was still a presumptive level 3.
By the way, is there something else to support the 15 points other than the DWI?
Well,
is there evidence of a history otherwise?
There is, although the 15 points is for a prior felony, so the only prior offense eligible was that one, right. Okay. And in fact, the defendant also talked about his, his treatment since he was incarcerated. He was actually not assessed any points based on his behavior while incarcerated.
Have you done this? Have you done SORA hearings?
I have not personally.
Because one of the concerns you have is that they are so cursory because the judge doesn't care. You got a sex offender, he's going to 3. Now, I'm being cynical, and I'm not suggesting that's what happens all the time. But on occasion, when somebody says, I've been through chemical dependency therapy and successfully, I've been to a number of things, I've done all of this stuff, but it ought to be brought in front of the judge, and some of that built-in bias that I think I would have if I was doing SORA hearings can get tapered a little bit because all of this comes before the judge. And that's why it would seem to me that, A, you make a preponderance and not clear and convincing, which reduces the, gives you a better view as a judge on the things, and then you do listen to this stuff.
But, counsel, your point is that the judge did hear all of
Absolutely.
this and made a discretionary decision to not grant the downward departure.
This was an extensive hearing. This was not a cursory hearing. This was an instance where, as I said, the defendant in the records before you, pages and pages of testimony. I'd also argue this is a sexually violent offender. This is somebody who molested 2 of his children. Actually, according to some of the document provided by the defendant in the briefs here, potentially a 3rd child as well. That's mentioned in the order of protection that was modified. One of the daughters, the abuse started at the age of 3, continuing until she was 9. So the court, the SORA court, though, clearly understood its role, which was not just to rubber stamp the determination of the board, which recommended
True, but
the level 3.
the points mean something. So his point is, or his argument is in part, that if a certain amount of these points, even if they won't take this particular defendant out of the level 3, automatically get him out because of the point score, it gets him closer to the 2, and maybe at that point the argument has perhaps is more compelling to the judge. The closer you move, how many of these arguments have we heard about being very close to the line, that makes a difference? Why is that not a strong argument on his part?
Well, I think in this particular case, because the defendant by statute is a sexually violent offender, which is not in the court's discretion, so he's going to be, reporting for life. So the consequences, I'm not sure how much, it matters whether he's a 3 or 2 in terms of
where they can live and mobility.
Right,
and
frequency,
like that.
those kinds of things.
So I understand why they would make it. It's anybody looks at the record, and I'm sure all the judges would agree with that. You can understand why the SORA court made the ruling. The question here is, did the appellate division apply the right standard, and is there a record here for us to allow it to admit it and have it being applied? It's going to be a difficult case, I think, to get the appellate division to change the determination, but the question is the standard, which is just needs to be consistent. We're concerned more with the law, I think, than with, you know, the individual inequities in this particular case. There's a broader principle, I think.
And I understand that, and I think, again, we come back to preservation because the concern here is that, as I think, you know, counsel explained, these records about the standard were never put forth before the court.
I wonder, though, is that, did you look at Gelati?
Yes.
And what do you, how do you distinguish the preservation here from that?
Well, I think that the difference in Gelati is that it was very clear on the record that the incorrect, we now know, standard was years. Here we don't have that. And I think that it's important that because the defense counsel would have known at the time that there was a conflict between the departments, I mean, that is how things get changed, quite frankly.
But I don't mean to keep picking on you for this, but if they do clear and convincing 5 times in a row, then they don't say anything, but they do this one. And then the next 5, they do clear and convincing. Do you think in the middle they did a preponderance?
I don't know on this record, but I think if you're counsel, you're making the argument that they should.
But and just to piggyback on what Judge Pickett is saying, certainly if they're going to deviate from the standard that they've applied over and over, one would think they do more than write one sentence.
Again, I think the point of preservation, counsel, or my opponent suggested that it was some new preservation rule. I would argue it's simply the preservation rule, and that the importance of that is to affect change for the direction that you see.
Regardless of what's going on in the Fourth Department, defense counsel knows about this split.
Yes.
They should raise it every single time, even if they think they don't have
Absolutely.
any hope of getting that panel to make a choice based on a lower standard.
Absolutely, because then when we get here, you have the record to decide that case, and that's not the case here.
Okay, counsel,
Thank you.
thanks. Counsel Rebuttal?
Yes, Your Honor. 2 things. First, I'd like to pick up on the point that Judge Pickett and Judge Rivera mentioned, that it is important that this be adjudicated and not rubber stamped.
But that, well, let me argue against my own point. I've never seen a written decision from a judge, as Judge Martichevitz did here, and as Ms. Moore points out, a rather extensive record. I mean, quite often, you go in and you say, Judge, this is what we got. And he says, I don't care what you got. You're going to get a 3, and that's that, and you have a right to appeal. But this was pretty extensive, don't you agree?
Well, it's extensive to the extent that they let Mr. Brown talk for a long time. But there was no testimony. It was just argument of counsel, and they let him talk. And then the judge said, I don't think you've shown me enough for a downward departure without saying what that standard was.
Does there have to be testimony from whom? Are you saying experts have to come in, or because isn't it usually arguments of counsel, and if the defendant is usually there and wants to say something, that's what the judge hears?
I'm not saying that there have to be experts or testimony. I believe, in fact, that the SORA statute and guideline don't contemplate bringing the victims in. That's out of bounds. But
if you were correcting me, I was speaking as if there was testimony, and you were telling me that it's not.
But it's well, I wasn't trying to. I'm trying to point out that it wasn't that it.
Okay, I'm not offended.
Okay. That it is important. And I'd also point out it's very important to Mr. Brown. He and his son are actually here in the courtroom today. They came down from Watertown for this because it's important to him to realize that his case is being taken seriously by the courts. And my second point was on a related topic. We talk about preservation at the appellate division. I know Judge Pickett and Judge Fahey are aware, but I'm not sure if the other judges are. Oral argument is not allowed in SORA cases at the Fourth Department. So it's kind of difficult to elucidate on something when you're.
But you could be in your brief.
Oh, yeah, you can put it in your brief,
and you
yes.
didn't, I don't think,
But
did
it's,
you?
but oral argument is not
But
contemplated.
you did not put it in the brief, did you?
I did put it in the brief. I alluded to the fact that the Second Department had this different standard. I didn't run with it any further than that, perhaps out of a sense that it wasn't going to go anywhere, that it wasn't going to change them.
Okay, counsel. Thanks. Thank you both. Appreciate it.